think I'll be live on 2. Okay, we are live. We are live on the YouTube. Kate Floss coming to everybody, letting everybody know the 1688 Bill of Rights. There's some of you that have been following my group. We're called the Oreo group, or usually we come from a group called the Maori Pen group. We're a group of people in New Zealand have decided to defend the 1688 Will and Mary. We actually took the case to court and we fought against it. It really was a battle of the 1688 Bill of Rights, our indubitable rights, with another battle of the 1990 pretended title of the Crown that's attached to the human rights and her and all the new world order. Now, we got this case, we took it to the court. We did prosecute Prime Minister Jacinda Ardern and Chris Farfoy, Minister of Justice Chris Farfoy, who is also Minister of Immigration Chris Farfoy, Ashley Bloomfield, and Andrew Little. And we brought them. We tried to get them to come to the court, but we didn't really accuse them of anything. We only asked for a declaration to say that our 1688 will and Mary exists today, and that we have power within that, and that we can use it. I wanted to show that we can use it to call our parliamentarians, or even the Queen, or anybody. We're all equal under the law. The Parliament can call you into the court. The police can call you into the court. The Queen can call you into the court. But you can call people into the court yourself. Now, we've got the verdicts just come in today. We haven't opened the verdict. We don't know what the judge is going to say. I've got my team on the side. You can't see them, but I can see them. We're going to be opening up this verdict today, and we're going to see what they said. But listen to me, it isn't the end. If they've turned down our declaration, we went to the court and we asked the prayer. I do pray for a declaration to say that our indubitable right are above all other declarations made around the world, and any of those declarations that are repugnant to our indubitable right of Will and Mary are illegal and void. Now, now I've lost what I was going to say. But anyway, the United Nations, the WHO, all of this comes under the supremacy right. And under the supremacy right of the 1688 Will and Mary, it does say that no foreigners should have any authority over us. And so this is the only means that we've got to go up against the New World Order and all of those. Now, just before I go, and I'm going to introduce some of the people that I've got waiting on the side here, and we'll get these people to say hi. You can't see them, but they are there. So the first one we've got is Brent Nash. Brent, say hi to everybody.
Hey. Hello, everyone.
Yeah, hello, everyone, he says. So Brent Nash, these are all the people that have been working with me on this case. The next one is Jodie Uther. Jodie Uther, a descendant of kings from England. So we've got some famous people. Jodie Uther, well, Brent Nash, who is a descendant of the paramount chief of New Zealand Maori. We've got Jodie Uther, who is a descendant of kings. Jodie, introduce yourself, because I can't say Uther correctly.
It's Uther.
Oh.
Hi there, guys.
Uther. All right. Jodie Uther, right, she's a descendant of king. We've got Diane Moore, who will have to turn off a microphone if she wants to talk. Diane Moore, who is a direct descendant of Hongi Hika. Hongi Hika, who fought against the missionaries. At one stage he was with the missionaries, but before he died, he renounced all the missionaries. And Diane Moore is a direct descendant of Hongi Hika. Say hi, Diane.
Hi, everybody.
Yeah, there you go. And then the last one who worked extensively with me is Maxine. And Maxine is also a direct descendant of Hongi Hika. I think she is. She's from a very, very big, important New Zealand Maori tribe. And I'm not going to say right now what everybody did, but I will be saying it later before we open. Now, we haven't opened the verdict. The verdict is in. The Jacinda Ardern, the Prime Minister of New Zealand, sent the Crown Council 2 members, Peter Dunn and Rebecca, and sent them both to challenge me. And so we didn't actually get to see Jacinda Ardern, but the verdict is in. They had made the order to strike out, which means they wanted to totally dismiss the case. The judge, the first judge, who was Palmer J was the first judge, and he said, no strikeout. He said, you will defend this case. And he said, come back in 15 days or whatever he said. They went away and they came back and they still did not defend the case. They didn't. And so they still have said to the next judge, who is, wait for it, a man called Cook, Justice Cook. Now, Justice Cook is a very important man because he is the one. Palmer J is the son of Geoffrey Palmer, who wrote the White Paper and the 1990 Bill of Rights. And Palmer J is his son. Justice Cook, in a case called the Arthur Taylor case, Arthur Taylor, a criminal and murderer, was sent through to the court with the Human Rights Act and asking for a declaration. And this case is called the Yardley case. That's called Yardley versus Taylor. I'll put all these links up for you later. But that was Yardley versus Taylor. Now, in Yardley versus Taylor, Justice Cook, they tried to attach, there's a law called S28 on the 1990, which says that all our 16.8 Will and Mary indubitable right are not affected by the 1990 Bill of Rights, which was really for Parliament to use, not for us. Well, they tried to bypass that and get their declaration. Justice Cook struck them down with his sword. He got his sword and he said, no, you cannot pass to the heavenly realm to get your declaration of God. But he said, you'll have to go to the High Court and battle that. Yes, it was Justice Cook. So we've got the 2 justices, Justice Palmer, who is the son of the man that wrote the 1990 Bill of Rights that's bringing in the New World Order. And then we've got Justice Cook, when they tried to get the pretended title of the Crown Declaration, I do pray, was struck down by the judge. And then when the Crown Council, in defense of Jacinda Ardern, and the Oreo team led by Kate Floss went to the court, and they tried to strike us out and throw us out. And Justice Palmer said, no, you will defend this case. And he said, I give you another 20 days to work together with the applicants, and you will come back and defend this case. Wow, that didn't happen. We came back to the case on Monday the 23rd. It's only Tuesday. Monday the 23rd, we went back to the court, and that's when we got Cook J. And when Cook J came in, the Crown asked to strike us out completely. We had asked for an extra 10 days to work with them. They wanted us to be more specific and more particular, but we weren't so particular. So now we're going to be going and opening up the verdicts. So this is all live. Now, we've got some very bad news. A new Prime Minister has just elected into Australia. And this is why the 1688 Bill of Rights is going to be so important to us. His name is called Anthony Albanese. Now, Anthony Albanese is, number one, he's a Catholic. And under the 1688 Will and Mary, that's illegal. He's not allowed to govern over us. He's also sneaky, because under the supremacy law, he is not allowed to govern in Australia because he's a foreigner, and foreigners are not permitted to govern. His father is Italian. full Italian, and there's going to be a big story to come back and tell you about that. But he didn't fake his birth certificate, but we've got another Obama bullshit story going on here. Anthony Albanese, after his mother, the Italian father, must have left as soon as the mother got pregnant. She was Irish Catholic. She was. And then when she was pregnant, he must have taken off, because on the birth certificate, it only put the mother's name. Now, this is sneaky. This has been planned since day one. This has all been planned. Now, he was told, apparently, that his father was dead, but suddenly, after he's already been elected into Parliament and all of that, he suddenly discovers that his father is alive, but his Italian father is not on his birth certificate. If his Italian father was on his birth certificate, he would not be permitted to be in Parliament of Australia as we speak. Now, he, in his first announcement was, he said, Australia is going to be a republic. We're going out. Once you get going out from a republic, then you then don't have your 1688 will and Mary protection. So this is the battle that's going on, people. You've got to stay focused. You've got to stay up to date. Now, I'm going to be singing you all a song before we go to the great opening, okay? So I'm going to be singing you a nice song. Now, lovely man sent this song to me. I'll try and do it justice too. Before we went to the court hearing with Justice Cook, I put up a prayer on my thing, and I said that I will fear no evil, that I will walk there and I will be strong, and I will go to ask for my sword and my shield in the chamber of hewn stone, to ask for my iron to defend myself. And I said a prayer on the count. Now, he sent me back the song, so I'm going to be singing to you. It's so beautiful. It's a little bit slow, but it's going to be a beautiful song. Everyone's going to be happy. Wait till we see. Right, smile. Okay, here we go. Hang on. Oh, where is it? Okay, so I'm going to sing this song. Oh, it's going to be beautiful. It's going to be a beautiful song. Right, I'll put you over there. Right, now you can't see this, but I can see it. I don't think I need to be too, so I'll just sing it over here. And I'll keep my video up over here, so I think you can all see me. So this is just such a beautiful song. I'll read it to you first to see what he says. So this is what he says. He sent me this. I'm not sure if he sent it before my court or after my court, but his name is called James Fittu, and he's a lovely, lovely man. He says, the Lord is my shepherd. He goes before me, defender behind me. I won't fear. I'm filled with anointing, my cups overflowing. No weapon can harm me. I won't fear. Alleluia. I am not alone. He's my comfort. Always holds me close. He always guides me, or us, through mountains and valleys. His joy is refreshing and restores my soul. Mercy and goodness give me assurance that I'll see his glory face to face. The glory. Alleluia. I am not alone. He's my comfort. So that is what he sent to me. And he's talking about the glorious Mary of Almighty God. And he's saying, don't worry, you're going to be okay. We haven't opened up the verdict, but we're scared. But now I'm going to sing it to you because it's such a beautiful song, okay? So here's my beautiful song. All right. Oh, no, don't do that. Right, go up there. Right, here we go. I'll see if I can do him justice. I'll try my best. Okay. I just wanted to tell you that the court, the High Court, which is called the Chamber of the Hewn Stone. The hewn stone is the stone that was struck with the iron sword. And the reason why it was struck with the iron sword is because they said, we no longer need guns to fight. You can go to the courts and fight, and we don't need to kill each other. that you can have your arms in the courts. They can have their arms in the courts, and we can have our arms in the courts. And people don't have to die. We don't have to have wars to fight. Well, the temple of the unhewn stone is the temple that the terrible people took Jesus. They bypassed the temple of the hewn stone, and they took Jesus to the temple of the unhewn stone. And of course, Jesus's face was slapped, and then Jesus got convicted in a secret hearing and put on the cross the next day. It was a very bad thing. Now, had Jesus gone to the temple of the hewn stone, he would have been able to provide us witnesses and defend himself in the light of day, and they would not have been able to falsely convict him and criminalize him. So this is what we're talking about. Now, the Canaan mines of New Zealand were used by the Sextus family to build the High Court of New Zealand, and it's called the High Court or the Chamber of the Hewn Stone. And they just recently in 2004 built another court behind it, which was made of wood. So it was made of the unhewn stone. And through the court of the unhewn stone, a man called Zowie was permitted to stay in New Zealand. This man is a man that's been convicted of Sharia law, and he had 6 life sentences against him, 2 death sentences against him, and the Attorney General fought like mad to stop him from coming to New Zealand, and he got into New Zealand. He's eligible to be in New Zealand Parliament in 2023, just so I let you know that. So there's a lot going on here that we're fighting. Now, the Canaan mountains that took the hewn stone to build the High Court, this is what he's saying. He always guides me through mountains, because the old courts of the hewn stones were always built by mountains, and Jesus moved the mountains for you and for me, and that is correct. So this is a holy war. Armageddon is here. We're in Armageddon. If you don't think so, we are experiencing Armageddon right here, right now. Are they going to strike Jesus down a second time? Let's go and sing a song and see. Right, here we go. It's going to be a beautiful song. Right, here we go. I'll try. Oh, wait a minute. I'll just start at the beginning. Okay. Lord is my shepherd. He goes before me. Defender behind me. I won't fear. No, I won't fear. I'm filled with anointing. My cup's overflowing. No weapon can harm me. I won't fear. Hallelujah, I am not alone. He's my comfort, always holds me close. He always guides me through mountains and valleys. His joy is refreshing, restores my soul. Mercy and goodness Give me assurance that I'll see his face, glory, face to face. Hallelujah, I am not alone. Hallelujah, we are not alone. No, we're not. That's it. And that is from Psalm
Nice one.
23. Psalm 23. Wasn't it beautiful? What do you think of my song, guys?
Yeah, it's good.
You're all,
Lovely.
eh?
Very passionate, Kate, very passionate.
It's a beautiful song.
Lovely words.
Hey, I think it's beautiful. All
Yeah.
right. So we're going to say some of the people, talk about some of the people. Sharon's just come in. We're going to talk about some of the people that were involved with this court case. Listen, I want to tell you that the first court case that went up with Palmer J, we had Brent Nash, we had Jodie Uther. Jodie,
You.
you.
Uther.
We had
Like
Jodie,
you.
right, we had
As in
Jodie,
you.
eh?
As in
Like
you, me,
You. We had Jodie Uther, Diane Moore, Maxine, we had Sharon Turner, we had Brent Nash. Now, the first case that went up with Palmer J, Brent Nash, the ones that was most important to that case was Brent Nash and Jodie. I think it was Jodie, Brent, might have been Diane, I think. We all sat up well into the night till about 3 o'clock in the morning. I think it was very, very, very
And
late.
Maxine.
Eh?
And Maxine.
And Maxine, I thought a couple of them went
Yes.
out. Well, we all sat up. We worked very hard.
Yeah.
We sat up into the night to get the case in to make it perfect. In that case, Palmer J let us carry on the case, and it was not stricken out. We thought we were not going to get further. We were surprised that we did get out. We got 1 foot in the door, but not 2 feet in the door. And what were we saying before, Brent, that we wanted to say about that?
But I don't recall.
No, I don't recall either.
we used a lot of language that was like,
No, I was just meaning what we were just saying before, that we had an argument about, I said save it for the video.
oh, I don't recall.
Well, what we're talking about was, I think what Brent was saying is that if we don't get past in this verdict today, don't worry. Oh, am I yelling here? If we don't get past in this verdict today, don't worry, because this is not the end for us. All right. So everybody be brave when we open up the verdict, but we want everyone to be not feeling sad. This is not the end. We're in this for the long haul, and we're going to fight further if we have to, but we don't know the verdict yet. We've got to wait for the verdict. My heart's pounding, but to be honest, I keep talking to you because I'm too scared to open it. But anyway.
Let's tell your people about that night, Kate.
Eh?
Because that was a different night. Let's tell the people about that night.
All right. You talk, Brent.
Night. You know, like we all got together and you know, none of us are real lawyers. Like I left school in the 4th form, and here we are, doing something that is huge. For the ramifications could go worldwide, and here's us people who are just average, everyday Joe Blogs people, all hanging out together until all hours of a Sunday night, trying to sort out a court case. It was just an amazing night. It
was a very amazing night. We worked really hard together, and We worked very, very hard together, and we got it perfectly, even right down to the right last words and everything. But we all knew that this was going to be an important moment in history for New Zealand and Australia and the Commonwealth and all of us. This whole thing is dependent on this case and the prayer that we sent. And we knew that it really didn't matter. We know that it didn't matter if we lose it or if we win it, because if we lose it, we've got a footing to appeal. So we really don't know what we've got, but we know that there is no loss here, that we know that this is historical. Yeah. Anybody else want to say something?
At least it didn't get struck out. That's the thing.
Well, we don't know yet, but it didn't get struck out on the first round. Now we're on the second round. We don't know if we've been struck out on the second round because we haven't looked at it yet, but we're going to be looking. Right, so Diane.
Remember, Crown Council never moved to strike it either. They were happy for us to have 10 days and them have 10 days.
Yes.
We asked for another 10 days for us and 10 days for them, and that is very extremely important. Crown Council said they were happy to give that to us. So Crown Council are willing to work with us, and I think they all know that this is an important case. But it's now, since the Crown Council did say that, it depends if the judges are going to let this through or not.
Yeah.
We don't know. All right. Who else?
I just want to say that this is what you do when you can see right down through to your great-grandchildren that things are going to be bad for them. You do whatever it takes. And like Brett, I left school at the end of third form, which is year 9. So, amongst us, our talent pool is very limited, but you do what you do because this is what you do. You do whatever it takes if it means that our grandchildren and great-grandchildren will be safe. Yeah. That's what you do.
Dead right.
Yeah, you do whatever it takes. So this is, when you go to the court of the hewn stone, that's what it says. It says that God says that it will be easier for a camel to get through the eye of a needle than it will be for a rich man to get to the heavenly courts of the hewn stone. What it's talking about is all these lawyers with these human rights in this 1990, the pretended titles of the Crown, they've been in a battle in New Zealand and Canada, Australia and England, trying to get through the eye of the needle with their pretended titles of the Crown to get a declaration, okay? And New Zealand did give them a declaration of inconsistency, but it wasn't a prayer. Our one is done on a prayer. And so the reason why they can't get it through the eye of the needle is because it's always about money. They're always going to fight this so that they can win a case, so that they can prosecute, so that they can get money for the people that they're prosecuting. But when you go with the 1688 Will and Mary, it's got nothing to do with money. The only thing it's got to do with is that your future generations are not going to be governed by people that they're not familiar with, Sharia law, Islamic law, canon law. They're not going to be governed by all of that. They're only going to be governed by the Protestant, and they're going to be much safer. And also the borders are going to be protected because it's got the supremacy law that says no foreigners can govern over us. And that cuts out the who thing. It cuts out many, many things. So you're not going to get money. Even if you win, you won't get money. But what you will get is a declaration telling all the parliament to stand down. And if they don't stand down, we don't have to follow them. If you get that declaration, they say parliament is in violation of your Will and Mary, then if parliament chooses not to follow the order, all of you, that is the time when all of you can say, I no longer recognise this government. That's when you can say it, but you've got to go and give them their chance to defend themselves first. So you have to make your prayer. You go to the court of hewn stone, you make your prayer. And then if you get the declaration, you then present that to the Prime Minister and the Governor General, and then they also get another chance. They get to choose if they're going to take up that prayer or not. If they choose not to, that's when you have to do whatever it is that you have to do. That's the time. All right. So we've got to go through the process here. All right. So Sharon was very, very good in the first case. The first case, Sharon came to speak. I don't know if you've got your thing there, what you said, Sharon. Do you still have it with you? Suppose you don't have it. She gave, I can't hear you because your microphone's off.
Somewhere.
Do you think you can find it? All right, Diane. Now, Diane was very helpful as well to us, and Diane has been the calming influence to us all. I'm very excitable, as you all know, and Diane is just the calming influence. And when you don't really know, when everybody's getting excited and you ask her a question, she will just come in so calm and peaceful and calm everything down. So she's our I don't know, our peaceful person. Diane, do you want to say something, dear? I can't, the microphone.
Now you've put me in the spot, haven't you?
Yeah.
I didn't really realise that I was the calmer, but that's nice to know. So I just feel like I'm just the leveler then, because I sit back and observe a lot, and I can get perspectives on things. So
Well done, Di.
yeah.
Well done.
She did very, very.
You're awesome.
No, well, she helped a lot on the case as well. She wasn't. She did when we had the meeting with Crown Counsel. Diane had translated the entire meeting and sent it to me. Both Diane and Jody did one, and Diane did one. They had to transcript a full 1 hour meeting and of what the Crown had to say to us and what we had to say to the Crown. So both Jody and Diane did that for us. Everybody's done a lot of work. Brent worked extensively well into the night with that as well. Maxine sat up on the second case. Have you found it, Sharon?
No.
Oh, it was so beautiful.
All had a lot of late nights,
We-
especially Max.
You certainly did.
We all,
And I felt, yeah, it's been quite full on. And I feel for Kate, because Kate's just been, absolutely instrumental to this case of actually getting it into the court and getting it to where it is today, and also having us. I mean, I feel absolutely honoured to have met Kate and be part of this team. So it's great. Yeah.
Same.
right, are we
Second
ready to go to look at the verdict?
Okay.
Share it on your screen.
Yeah?
Wait till I finish my chocolate.
Green.
Right, finish your chocolate. We're going to, now, if you're on the YouTube, I've got two going here, but if you're on the YouTube watching live, we're going to go to the verdict and we're going to read the verdict. I'm so scared. I've got my thing here.
Don't be
ready for
scared.
tears, and we're going to read you the verdict. Right, have you finished eating your chocolate yet, Brent?
Yeah, go for it.
Right.
Let's do this.
Are you ready? We're going to the verdict. Oh no, I'm so scared.
Open it up, lady.
Right, I'm going to share this. I have to open it first. Right, I've opened it up. Right, I've got it open there. And we're going to, oh, where's my Zoom link gone? Are you there?
We're still
Yeah.
here. We're still here.
Right, there you are. Right, I've got to go to share screen. The YouTubies, do you want me to go to whole screen or do you want me to go right onto the thing? Which one is better?
Just read it. Just read it.
Go on.
Yeah, read it, because I'd read it before you finish.
Eh? Right, I'm going to read it.
Yeah, read it, because I'd read it before you finish reading.
Who's read it?
Maxine will have read it by the time you got through 2 sentences.
Oh, that Maxine. Yeah, I'm scared. I'm too scared. I don't want to open it.
Open it up, lady.
Shit. Right, you ready?
Yep.
Yeah.
All right, I'm going to open. There's two here, so there's. Oh, I don't want to open it.
Open.
This is a
You
notice.
better bloody open it.
Oh shit! I think we've been turned out.
No,
Oh,
No, no.
oh no!
Tell me,
It says
Just
this
tell
is a
you that-
notice pursuant that there will be a judgment delivered in the above matter at 5 p.m. today.
that'll be
Yeah.
the second.
Where's the
second
next
one.
one?
The 5 p.m. one will be there now.
Should we go there?
Yes.
Oh my God.
Where?
Should we go?
No, he didn't send us the link. Oh, for God's sakes.
No,
This-
pull
No,
your, go back.
Stop.
back to
Calm
it.
down.
What?
Calm down.
What do you want me to do?
Go to the one
Right.
above.
Breathe.
Here?
And have a look.
No,
Where?
no, back.
Here?
One that one.
There's no
Just
link.
wait.
Read it.
Click on the
It says
PDF in it.
attached.
There's an
Oh, the
attachment.
Attached
PDF
is
in
a
it.
reserved judgment.
Go above.
There's a click
There-
on the
It's
PDF.
there.
There.
Yeah.
He delivered it without us. I'm glad. Oh, God help me.
Open.
Open it.
He said it. What's R11? What's R11, Maxine? Go and find me R11.
Just open it.
Just read it.
Oh, no. Oh, I think we've lost it. He says the first applicant in person of friggin' Catherine Sixtus, Kerry Campbell, Jacinda Ardern, Chris Farfoy, Andrew Little, Ashley Bloomfield. Oh, we've been struck out.
Just carry on.
The first applicant by interlocutory application dated the 19th of
Keep going.
May. The respondents apply. He said the respondents apply to strike out the applicant's statement of claim under R15.1. That is not fair. Of the High Court
What's
rules.
You've got to
15.1?
read the whole thing.
All right, on the basis that the statement of claim discloses no reasonable arguable court case, that it is likely to cause prejudice and that it is vexatious. What does vexatious mean?
At any case.
What does hello, it's Nanny Kate there. What does
It just means upset.
what does vexatious mean?
Upsetting.
Eh? The application is opposed by the applicant. So the application is opposed by the applicant. So we don't know what the judge is going to say. We don't know what he's going to say, but oh, God.
Vexatious means a source of irritation or annoyance.
He said that our case is a source of irritation and annoyance.
Or
I
an
don't think that's a good excuse to strike out a case that you annoy me. You annoy me,
grieving,
eh?
distressing, troubling, grieving, distressing.
I called them
Yeah.
trouble. I called them annoyance. Thank you. That's EM Real says it's tending to cause annoyance, frustration, or worry. Well, of course it. Well, how do they think they feel?
We need to hear the whole thing to get it in perspective. We need to read the whole thing.
All right, we're going to go to the
You're-
next
you're
bit.
just
No,
taking
I'm too
my-
scared. I can't open it. All right, go to the next
Do
bit.
you want me to read it? Do you want me
No,
to read
no,
it?
no, 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 no. I'm going to read it. I'm going to read it.
The
Right.
whole thing.
The background.
thing.
All right. He's given, always put the prayer in. Here's the background. I'm not going to go to the answer. Here's the background. I'll read it to you. The applicants, which is us, all my team, Team Oreo, and the Maripian Group, the applicant's statement of claim was filed and served in March 2022. The nature of the claim advanced is not clear, but it is apparent that it is a claim for declaratory relief. So they've got that. The declarations sought are pleaded in the following terms. So he's put it nicely for me. We do pray a declaration to consolidate the 1865 to 1908 Native Rights Act, and including a new declaration to deem the European progeny and native Maori progeny posterities and New Zealand people to be deemed to be natural born subjects of Her Majesty Queen Elizabeth II of the United Kingdom and Ireland as it pleased Almighty God. Now, if you're from other countries and you don't know what this means, in 1865 and 1865, Queen Victoria adopted all the New Zealand people and made all New Zealand people subjects under the protections of the 1688 Will and Mary. In 1908, when Queen Victoria passed away, King Edward the Seventh, I think either the 7th or the 8th, King Edward the 7th, I think it was, he consolidated that declaration and made all the people of New Zealand subjects protected by the Majesty of England, and we all came under the protections of the 1688 Will and Mary. So I went to the court to ask for a new consolidation of that and to declare that the native AB original will, which is the will of Will and Mary of 1865 and European ancient will of 1688, English speakers of New Zealand to their progeny be protected. We've asked it for all our future descendants to be protected by the Queen's Courts of Law to extend over the persons and properties of all Her Majesty's subjects within New Zealand. And that was prayer number 1. There are 4 prayers. So prayer 1, we ask for a brand new declaration to say that we're protected under the Will and Mary. Here comes prayer 2. Now, prayer 2, I'll just explain it to you a little bit. The 1990 Bill of Rights, which is the pretended title of the Crown, has a section called S28. S28 says that all other rights are not included in this because the 1990 Bill of Rights has a thing called justified limitations, and they can stop anything that they want through the Health Act and through the WHO, anything. But it's got a clause of S28 that says, in regards to these other rights, you can't stop anything. The other rights have all power. So our Will and Mary indubitable right come under that, okay? So we said we do, and then they tried to attach the United Nations, the WHO, and also America. They tried to attach all of them onto S28 in a case that this man here, Justice Cook, ruled on. So it's quite a lot of stuff going on here. Prayer number 2, we do pray a declaration to the effect clearly stating the applicant's ancient 1688 subject right under Almighty God exists pursuant to S28. Other rights and freedoms are not affected, and of the 1990 New Zealand Bill of Rights ordinary law, without ordering any specific action pursuant to Section 2 of the Declaratory Judgments Act. So we've asked them to make clear in regards to S28, does S28 include all other United Nations law, or does S28 only apply to the 1688 Will and Mary? That's what we've asked them to clarify that. Prayer number 3, we do pray a declaration to the effect that when 2 subordinate laws, 1993 Electoral Act, when 2 subordinate laws conflict with each other, with both an argument for the declaration of indubitable and progeny right that pleased Almighty God, and an argument for the declaration of inconsistency, fundamental right, which right shall be deemed to be taken to be allowed? Which declaration, when you have 2 declarations, whatsoever shall serve the Majesty for all times to come from the Will and Mary. Now, This is very significant because if you remember at the beginning of the video, I was talking about Anthony Albanese. The 1688 supremacy law forbids foreigners to govern over us, and that actually forbids him to be in Parliament. And I'm reckoning that he's going to lose his seat if any Australians take this law to court. Now, in New Zealand in 1993, we had a law, Section 55, that said foreigners could not govern over us, and that matched with the supremacy law of the 1688 Will and Mary. But in 2006, Helen Clark added an extra section 55AA, and she said foreigners can govern over us in special circumstance. And so that one was in line with the human rights in the 1990, and our one that no foreigners could govern was in line with the 1688 Will and Mary. So we've got two rights that are opposed to each other in one law. We've asked for a clarification of that. That was prayer number 3. Prayer number 4, we do pray a declaration that every particular of the New Zealand Parliament, including high courts and all ministers, to dispense with laws and exercise of late in clear language, and particularly the 1688 Subjects Bill of Rights, New Zealand, I'm laughing too, or 1990 New Zealand Bill of Rights, or fundamental rights, or any rights, and to avoid confusion that has been cruelly and deceptively dispensed of late. So what we're saying is they've been sneaky. Whenever they've used this 1990 Bill of Rights, they don't call it the 1990 Bill of Rights Act. They just simply call it Bill of Rights. Now, just saying Bill of Rights, it could apply to anything. It could apply to human rights. It could apply to the Will and Mary indubitable right. It could apply to anything. Sharia rights, Talmud rights, anything. So we've asked them, because it does say in the Will and Mary that they must be particular about it. And so I said they need to be more particular when talking about rights, because our indubitable right are above all of them, all right? Because ours is the only one that actually says on it in legislation that everyone is under the power of Almighty God. Ours is the only one that says that. So then I said, so help me God. So there's 4 prayers for you that are new to this. For you that are new to this, it might be a bit, I'm sure you can all understand. Right, we're going to go to the next bit. So that is the background. I'm too scared. We're not at the verdict yet. So he says, the proceedings were first called before Palmer J on the 2nd of May, who recorded the Crown's view that the statement of claim was unintelligible and should be repleaded. So they said, throw it out and come, but they didn't say it's no good. They said, you have to come back and do it again. He said, you can do better. You have to do better than what you've done. And I have to say, I agree with them. We put in a very, very sloppy thing, but we all only have high school educations, and we did the best with the knowledge that we had. Yes, it's a spiritual war, real. Laws of God's kingdom apply in man's kingdom if we submit to God. Repentance as a nation is key. Yes, he's right. Yes, that's it. Thank you very much, real. And then, so everybody's on this live and people can talk to me. You can send me messages and I'll read them if I can. Now, so he said, Palmer J recorded the Crown's view that the statement of claim was unintelligible and should be repleaded. Ms. Sixtus submitted that the applicants, we said that we had done quite a good job in their pleadings and that we stood by our pleadings. So we said, we're not going to redo it. And so, but Ms. Sixtus advised that she was prepared to work with someone from the Crown to tidy up the claim. Palmer J recorded that the Crown would engage with the applicants to see if the claim could be tidied up. But he also said that the Crown was likely to apply for a strike out of the proceedings, and that the proceedings should be called before the duty judge in the week of the 23rd. I'm spitting because I'm so excited. In the week of the 23rd of May, which was on Monday, and we all had to go to the court. I have to drink some water. I can't even breathe. Now, so we're going to find out. So those are the arguments. Oh, now he said, the claim has not been amended, which I disagree with. I didn't change the original claim. A meeting did occur between the Crown Law Office and Ms. Sixtus concerning the proceeding. Ms. Sixtus, I said this in court, Ms. Sixtus is critical of counsel in relation to that meeting. She also says that litigants in person should be accorded latitude, and it is not appropriate for the claim to be struck out. What does litigants mean? Is that us? Hello?
Litigant, yeah, isn't it like
Who are the
aren't they
litigants?
lawyers,
Does any?
litigators
Oh,
Okay.
thank you,
pushing for
Ian.
something?
Hey, what's the litigants mean? Is that us?
They're pushing for something. They're trying to get something through. Litigants,
All right.
litigating lawyers.
Litigation.
Not Norma said
Yeah.
that's you, that's us. So
Yeah.
I had complained because I said that when the Crown Counsel came to meet with us, when we made our full press, we didn't actually say anything against the Prime Minister. We only said that these are the things that are upsetting us, and this is why we want to have this declaration. But the Crown tried to force us to be particular against the Prime Minister about which right that they had violated. But we said we didn't, but they didn't tell us that. We only found out that after they had submitted to strike on late Thursday night or Friday. We only found out that. And so we had to, all our team sat up all night Thursday, all night Friday, all day, all night Saturday, all day, all night Sunday, and rewrote everything with our defense. And then we put it into the court. The court time was 10 o'clock. We put it into the court at 9:30. And when we went in, there were a few people before us, but as soon as it got to us, Justice Cook looked right at me and he said, I have received your response to them. He said, I've got it here. It's right in front of me. I've got it right in front of me. And he says, I know what you're talking about. And I thought, oh my goodness. So he had it. And he said, I have read it. All right. So I don't know if he's going to be, the Crown was still likely to strike on the 23rd of May. Now he says, the claim has not been amended. Ms. Sixtus is critical of the counsel. And she also says that the litigants, which is us in person, should be accorded latitude. So we've asked for latitude. I know that word. And it's not appropriate for the claim to be struck out. See, we went there with our swords. I had my sword and shield of iron, and they had their sword of clay. And I've been fighting them. Let's going to see. Now, number 5. Now, let's see. Number 5, in the meantime, Ms. Sixtus, which is me, Kate Floss, and other applicants sought to file a further proceeding, which was referred to Palmer J under 535 of the High Court rules by minutes dated the 18th of May to be struck out further proceeding under the 535. Now, this is where the whole thing went crazy. We had filed a separate claim a couple of weeks after our first one, which completely different. I'm not going to go into the details because it's going to be too long, but We had not attached the laws that we needed to use. All we had to attach, it was pretty pathetic, really. All we had attached was a note from the government website. So it was very extremely pathetic. And it got, and for some reason, the clerk, who was a new clerk, took that to the judge, and service orders were not given. Now, immediately when service orders are not given, then it should have just gone away. They should have just sent us a note, and then that should have just gone away. But they didn't do that. For some reason, they said to the judge that we wanted to consolidate it with this case. I don't know why they said that to the judge. And so we sent them many mails saying, no, but that case was not given the right for service, and the clerk, who should not have done it, if we lose this case, he's going to be in deep trouble. The clerk sent it to the Crown Counsel, who were involved with this case, which the clerk should never have done. Yeah, he never should, and it messed up our whole case, and we ended up.
That gives us a good basis for appeal if it does not be good. If things aren't looking good, that gives us a good basis for appeal.
Yes, Brent. Brent's saying that that's going to be, if we've lost this, we don't know yet because we haven't got to the bottom, but that gives us the basis for the appeal, because they never should have done it, and it ruined our whole case. Soon as the Crown Counsel saw that 535, that we were struck out because we didn't have enough evidence, and we hadn't attached the correct laws, the Crown Counsel latched onto that law and attached it to strike us out and say that this was the same and we hadn't attached laws. But that is not true, because our case had already been accepted and stamped by the court as being worthy and given permission for service. The other case had not. So I don't see how they could even think about striking out this case that was already given the letters for the service. So the court already gave it. You can't take that back. So a lot of skullduggery going on down at the courthouse, whether it was by accident or design, but let's not be critical until we get to the end. Now, we're all going to be getting near to the end. We don't want everybody to be feeling sad if we don't get this, all right? So don't be feeling sad. He says, so this is not good for us. He says, I'm satisfied, this is from Justice Cook, I'm satisfied that this proceeding is plainly an abuse of the court. It does not adequately identify the decision that is challenged, the legal grounds of challenge, or a proper declaration of legal right. The applicants need to take legal advice. Oh, no. This was Palmer J's ruling for the second case that was the mix-up. And he said, and he was correct, he said it didn't have a proper declaration of legal right, and the applicants need to take legal advice about how to frame their concern in a way which is recognised in law. It would be unfair to the respondent to require a response to this proceedings as it currently stands. He said, I strike out on that proceeding. It was struck out. And this was, he was striking out the second case that we had done badly, not the first case. But here's where the problem arose. He said, I also note that I inquired of the applicants, but he didn't. He inquired with the clerk, not with me. He inquired with the clerk about the relationship between the proceedings and the proceedings brought by some of the same applicants in the Sixtus versus Ardern. So that our main case was Sixtus versus Ardern, and the second case was Moore and Sixtus and a couple of the same group, but Moore versus Minister of Immigration, a separate case. That case was already struck out and we accept that. But then he said he had inquired to see if we wanted them put together. And he said the
Mm.
applicants have clarified that these proceedings are separate. Yes, I said they're completely separate. And he said, but advised that they would apply for a consolidation of the proceedings. Now, this is not true. I think that the clerk, who was not an English person, messed it up. I wrote him a note and I said, the first case, Sixtus Ardern, is asking for a consolidation of the 1908 Declaration of indubitable rights of subject status. That's the consolidation. And I think that the clerk messed up in the English, and he told the judge that we wanted a consolidation of cases. So that,
Perfect.
yeah,
Silly quid. He's going to be sweeping floors and cleaning toilets.
he caused quite a lot of trouble. And not only that, he started sending the Sixtus, the Moore case was filed in Auckland, and the Sixtus case was filed in Wellington. We deliberately filed them in separate areas. We don't know how it got sent from Auckland to Wellington because we had deliberately filed them in different courts for a reason, for that reason. And we don't know why it got sent from Auckland to Wellington for a start. And then the clerk in Wellington started sending the Sixtus case to Auckland. Oh, it was just a nightmare. So in the meantime of fighting all of this case, we had all these crazy things going on. It was like, we were writing letters, me and Maxine, everyone was involved, but Maxine worked exceptionally hard. We were writing letters all day, all night long, trying to get out of this mess that had been created. Now let's see what he says next. The Crown has now applied to strike out on this proceeding. Sounds like, oh, yes, not yes, Norm. Norm's saying it sounds like the orchestrated muddying of the waters. I think it was deliberate by certain people sabotaging us, but we're not going to talk about that until we get to the end of the thing, because we haven't said, we don't know what the judge's ruling is. So let's not criticise until we see, but we've certainly got a lot to criticise. Eh?
It's looking that way. It's looking like it's deliberate muddying.
It does look like deliberate muddying of the waters. They certainly worked. We complained when we went to the court. We said to them that they have all acted unfairly. And we said to them, you know what? I said this in court. I said, you know what? We all are unqualified. We all are not lawyers. We don't have any qualifications. And I said, the Crown has got extensive qualifications, and it's not necessary for them to carry on in this skullduggery. Wait, who's that noise?
Sorry.
Turn your microphone off.
Okay.
Right. Is it off?
I don't know. I'm going back outside now, so I'm good. You're good. It's quiet.
Right, be quiet. All right. So, please. All right. So, now you made me forget what I was saying. So, we said in the court, there's no need for the Crown Counsel to act with all of this orchestrated muddying of waters and skullduggery, because we said they're already lawyers. They've already got a lot of advantage over us already. There's no need to take advantage of their advantage over us. That's what we said in the court. We were upset. So that was the complaint that we'd made. Be quiet, Brent. So he says the Crown has now applied to strike out the proceeding as anticipated. The applicants earlier filed an 11-page memorandum responding to the Crown's criticism of the claim, which includes a list of grievances Ms. Sixtus explained were to form the part of the claim. So this might be good. Me and Maxine sat up all night until the very early hours of the morning. She was up I'm working from Thailand. She's working from New Zealand, and it was 10 o'clock, 11 o'clock, 12 o'clock over here in New Zealand, in Thailand. So it was okay for me, but she was like 3 o'clock, 4 o'clock, 5 o'clock in the morning working on this. And we rewrote a new claim, and luckily for us, this time I was particular to each person on how they had violated the 1688 will and Mary. So we got particular and we added it as part of the claim. I don't know if this is good news. I'm getting scared now. Oh, he struck it. The proceedings came before me as duty judge on the 22nd of May, and he says, I have heard the respondent's application at the end of the list. Oh. He's giving the relevant strikeout principles, why they are entitled to strike out a claim. I think we've been struck out. Everybody brace yourself, but this is not the end. We're going back. Rule 15.1 provides that dismissing or staying all or part of a proceeding, the court may strike out all or part of a pleading if it discloses no reasonably arguable cause of action, defence, or case appropriate to the nature of the pleading. So he said we didn't have a reasonable cause of action. B, if it is, if it is likely to cause prejudice or delay. I don't know what that means. If
I
it
don't
is,
think, I think
Ah.
he's discussing.
look at this.
He
If
ha-
it
he
is
hasn't-
frivolous
he
or
hasn't said that.
vexatious. He called us
He-
vexatious. What the hell can you stop people going to the court because they said it annoys me?
No,
Matson.
no,
Yeah.
I don't think he's struck out. He's given his judgment yet. He's simply speaking, now he's talking about what the respondents are saying at this stage.
Yeah.
All right, so we're not dead yet. Right,
No.
we may still be alive.
He's just giving you the principles of
Right.
strikeout and how they can use
Remedy.
it if they were going to use it.
All right, so we might not. What are you saying that Norma's saying something about that means remedy? He's saying that, what was that? Because I said a word that I don't know, and Norma's helping me. Anyway, he said the remedy. Prejudice. Okay, the prejudice or delay. So the remedy. So it would likely to cause a prejudice or a delay in the remedy. Okay, I see what you're saying now. So thanks, Norm. Nev is a traffic child. Yes, you didn't put remedy. I did though. I did put a remedy. I have asked for a remedy. I said that the remedy would be the declaration to confirm our rights. But let's just keep reading. But we'll see. We'll have discussions about that, Norm. Yes. So Norm is saying we did not put. Oh, I see. Norm is saying that we didn't put what the remedy is, but that's not the one that the Crown Council used. Crown Council used that we were vexatious. So, and he said, if it is otherwise an abuse of the process of the court. So that's what they're saying, right? What's going to be next? 9. Oh, I'm scared. In the present case, the respondents say that the claim is unintelligible. They did say, they said it's unintelligible and raises no proper matters to which the respondent can meaningfully respond. We had claimed that by using the WHO, the Institute in United Nations Law into New Zealand and all of that, we had claimed that the New Zealand Prime Minister was not making sufficient protections for our country because the 1688 under the parliamentary laws that they have to follow is that they have to make suitable protections for us that uphold our indubitable rights, meaning the main one would be to protect our borders and prevent foreign nations from coming in to govern over us. We have said that they have not been protecting our borders from,
You got to go out.
eh? Hey? I think she's let the cat out. So we have been saying that was the reason, but the council said that we did not have any, they could not meaningfully respond because they didn't, our case was unintelligible. So everybody else understood it. I understood it. But anyway.
They just argued there's 3,000 United Nations personnel in Nelson at the moment.
Right, Brent is saying that he's heard that there are 3,000 United Nations in personnel. We'll see what they're saying on the side here. They're saying, you didn't put your remedy in your representative. EM Real says, a vexatious litigant is someone who files multiple lawsuits against another person for the purpose of burying him in... I did not.
For the purpose of what? For the purpose of what?
EM Real says, have a listen, I'll read again what he says. A vexatious litigant is someone who files multiple lawsuits against another person for the purpose of burying him in paper. Well, that was part of my complaint because I have said the government have been issuing multiple lawsuits against the people of New Zealand, and we can't fight against them anymore because there's too many laws. We said there's too many and we can't fight. And then Not Norm says, yes, but I think, here's what Not Norm is saying. Not Norm is saying, yeah, but I think because you have presented them in the form of a prayer, there's nothing they can do in response. So it's wasting the court's time, hence it's vexatious.
Okay.
But if you're seeking a declaration, you're not asking for an argument.
No.
That's the whole point of it.
I only just wanted a
And
declaration.
you even said that to the court on Monday. You said that. You said we're not here to oppose anyone. We're here to get our declaration.
Yeah. We said that in our thing. We said we're not opposing anyone. We only just want the declaration. What I told the judge, I said in my plan, we put the 4 causes, and we only just we said at the bottom of my thing, I said in my conclusion that we are not prosecuting any one of them for the 4 causes, but we've asked for a declaration so that we can come back later and prosecute them one by one. Because there are so many repugnant laws that they've used, and we had so many, we knew that every one, if we would have to go to the court one by one for each one of them, and each one of them would battle with us because there would be a battle over which one is supreme, the 1688 or the 1990. So in our plan, we would get the declaration first to say that the 1688 was supreme, and then we would go to the court one by one and prosecute them one by one. That was always our plan, but it was the council that tried to force us to prosecute them in particular, and that caused the problem because he didn't understand that I just wanted a whole declaration. You are requiring clarification of the yes, Not Norm. This is Not Norm has said, I'll read it to you. Not Norm, EM Real said they had to use that to put you off for longer. Yes, we're good. Everything that you're saying, Not Real, but let's wait for the end because he hasn't ruled yet. So we don't know what the judge is going to say. We don't know. And then Not Norm has said, my understanding is that you are inquiring clarification of the application of the 1990 BORA, BORA, because it is an act and it's already been deemed to be an ordinary law. And so I'm not even knowing why they're giving it declarations in the first place, because it was an ordinary law and it was never intended to be a constitutional law. And we found in the select committee, when they wanted the 1990 Bill of Rights, in the select committee, they said that there would never be any remedy available for this 1990 Bill of Rights. They already did that in the select committee, and that was in 1993, in pre-1990 from the white paper. And then they came back 1990, and then 30 years later, they buried that, but I found it. They buried it, and they came back and went to the court, and they got a declaration of inconsistency as a remedy for Arthur Taylor. And the select committee, when the 1990 was written, they were never supposed to be allowed a declaration of remedy. And that was my case, that I wanted them, I asked in the prayer, if you've got two laws, one of them is the subordinate from the 1990 that are conflicting, which one would be the rule? And if they said the 1688, so the 1688 is not the BORA, can you correct that, please? Not Norm. Not Norm. Make sure you put that up. I'll put it up myself just to make sure everybody doesn't get confused. The 1990 is the Bill of Rights Act, or called BORA, and the 1688 is just called Bill of Rights, full stop, and it's usually called Will and Mary. So it is the 1990 that is the, all right, thanks, Norm. Thanks, Norm. So my understanding is that you are requiring clarification of the application of the 1990 BORA as opposed to the 1688 BOR. That's right.
Yeah.
Yeah, all right. We've got it. Very, very good. So we've put that up now. Not Norm's done it. Well done. So, yes, that's the clarification that we were looking for. And so, so then he says, in the present case, the respondents say that the claim is unintelligible and raises no proper matters to which the respondents can meaningfully respond. But, you know, I disagree. I believe that this argument deserves a place in the halls of the court, in the chamber of the hewn stone. Now it's going to get here. This is ruling. Here's the ruling, I think. I think they usually say it's the ruling, don't they, Brent?
Probably.
All right,
I don't know.
let's read and see. The court has jurisdiction to strike out a claim that is unintelligible and lacks proper foundation. Amongst the circumstances in which claims have been struck out under 15.1 are pleadings they are unintelligible or which set out excessive evidential matters. Oh, I put too much in. Such proceedings can also be struck out through the procedure contemplated by 5.3a. 5.3a is when you don't attach the correct laws, and occasionally also under the inherent jurisdiction. What's inherent jurisdiction mean? Anybody on there know?
That means the learned inherent, you know, like inherited. So it's come down to just.
Inherited, so precedent law, is that right? So it can also be struck out by precedent. And So he's probably going to say that it's the president from the second case that got mixed up, maybe. Occasionally under the inherent precedent. Oh, hell. Under 535B, now I will just tell you this. 5.35B is called, it's a law that was only just introduced in 2017. They're getting sneaky down there and they're finding ways to stop us getting into the courts is what what they're doing. And 5.3A was created in 2017, and it only says that if you have not attached the correct laws, then they will not allow it to go to service to the people. So you've got to attach the correct, everything has to be up to standard. And so if you don't have that, then they will strike it out immediately and it will not go to service. But my complaint is that mine had already been given the service from the judge, had already said, yes, it's okay. And we got the service papers for Jacinda Ardern and we did serve them. So that's my complaint there, because they should never have given the service papers in the first place. They should have sent me back and said, these are the reasons why we will not give you service. And we could have fixed it before this occurred. So that's a bit sneaky on their part, isn't it? Eh? So let's see, keeps going to what he says. Under 535, proceedings can be struck out if it would be manifestly unfair to the respondents that they be required to plead. And if right-thinking people would regard the court as exercising very poor control of its processes if it were to accept the pleading. If a proceeding is fundamentally defective for these reasons, it can be struck out on application under R15.1 as well as under R5.35B. And not Norm is saying, okay, I agree. Not Norm is saying you must cross your T's and dot your I's.
Yeah.
Yeah, he said, I think this is good. It says giving you the clues as to how to approach it next round. So what Norm is saying, he's saying, he or she. Are you he or she, Norm? Could you just tell me so I don't be calling you she when you're a he or he when you're a she? So not Norm is saying don't worry because the judge is giving you the clues. All right, it's a he. He's a he. Not Norm is saying, I'll call him Norm and not Norm because Norm is Norm. So Norm is saying that the judge is giving you the clues. So if in the event that we lose, he's telling us that, yes, you can come back with this, but these are the things that you need to fix it. And if you do that, you might possibly get through the eye of the needle to the chamber of the hewn stone. So we might get there. Okay. So don't be sad. The fight has just begun.
We're just learning. We like Norm says, we're getting the clues, and we'll all once we've finished reading the verdict, we'll all go over what was written with a fine-tooth comb separately, and then come together again and replan our attack.
Yeah.
Boom. Doesn't matter which way it goes. We're not giving up.
No, we certainly cannot give up because all our countries are in a lot of trouble, especially our Commonwealth countries, our Commonwealth, New Zealand, Australia, United Kingdom. We're all in a lot of trouble. So I reckon we're going to get a bunch of these common law people that have been going down the wrong road, banging their heads against brick walls, and they're really, really clever, way more clever than us. And once they clue on to doing this, they're all going to come in and help us, and we'll be just fine next time around. Get proper people. This is just sharp. Norm says this is just sharpening out the teeth, and we are very hungry. He says, yeah. We're sharpening our teeth, and we're going to be going back with our sharp teeth and getting these people. Now, number 11. All right, listen up, everyone. I'm going to be here all day. Distilling the principles from the authorities. It seems to me that the court, he says, it seems to me that the court should strike out. Well, he said should. He didn't say will.
Good.
Should.
Yeah.
He said he should strike out a claim when the pleadings are so unintelligible and it would not be appropriate to require a response to them. If the deficiencies can potentially be remedied by amendment, then it would be appropriate to give the applicant and the plaintiff the opportunity to re-plead. But if it is apparent from the nature of the claim that no appropriate cause of action or other claim is capable of being identified, then the court should strike out the proceeding. This power should only be used sparingly in light of the fundamental right of access to the court. But the rights of parties responding to litigation must also be respected. So he's saying, we see your point of view, that you've worked very hard on this, and we know that you really want to do this and that you're good in heart. He's saying, we know that you're good in heart and you've not just been vexatious and evil, but you just haven't quite got it right. And he said, and because of that, we have to take especially into account the respondents and how this would affect them, and it has to be more in their favour than what it would be in our favour, because they have to go on the favour of the one that you're prosecuting, not in the favour of the one. So, here Norm says, boom, I love it. And yeah, we got a little high and then we got a little low. He's a great judge, this Justice Cook. He's really great. He's left the door open and your foot is still in, he says. He says. Everybody clap, clap. Are you clapping? I'm not going to go on if you don't clap. Clap. I'm on the YouTube. All right. Is everyone still there? Because I can't hear you. Right. Maxine, are you there? Oh, Ian Real saying, yeah, baby. And Norm's clapping. All my friends are clapping. Yeah, baby. The door's not closed. It's open. We've still got 1 foot in. We've got 1 foot in and 1 foot out, which is better than both feet out, right? Oh, and then, and Ian Real says, listen to advice, yes, and accept instruction, exactly. That you may gain wisdom in the future.
That's what I've said to you all along. The judge is going to give you guidance. The judge will always give you guidance. And we've got to pick up the guidance that's what he's in within what he's written. And then we will come back real strong.
We will, because we know all where we're going. We know what the fight is now. And we know where we're going, but we just need some people to come in and help us. But I think we've got a couple of friends here. We've got Ian Real that's going to be helping us, I think, and Norm's going to be helping us, I think. So we've got people that are helping us now.
Dare I say it? You need almost someone that's confident in the Supreme Court, High Court field of things. We need an ex-lawyer, someone who needs a job.
We've got Norman Real, and they seem to be doing pretty well, advising us on all the vocabulary, and they seem to know everything exactly what the judge says. But so I think they might be on board with us, and I think they seem to be pretty clued up, and so I hope you don't mind, Norman, Ian Real. We might rely on you a wee bit here to help us get through, because it's not over yet. The door's still open. It ain't closed. So he said, yeah, we have to think about, right, it ain't closed. So he never just said, we strike you out, this is it, you've got not allowed to come back to the court. He said, yes, you can come back if you fix the deficiencies. Now let's go down here. That's no arguments. Oh, shoot. Oh, so usually I swear, everybody knows I swear like a trooper, but I'm trying not to swear today because we have to be respectful to the court. Let's pretend that we're in the court and I have to be respectful. So I'm not going to swear, but it's hard. So it's just perfect. So arguments. All right. Mr. Gunn, who was the Crown Counsel, and I will just tell you something about the Crown Counsel. They actually have been lovely all the way through. They've been defending Jacinda Ardern, and that is their job. But they have, except for they did not contact us, as the judge had ordered them to contact us, and they never ever told us. I think that they could have told us. Well, they wouldn't. They didn't tell us any. They didn't tell us they were looking for particulars. But anyway, they were still quite lovely, the both of them, and another
They were
lady.
arrogant,
Eh?
Come on.
Eh?
They were arrogant.
Well, it was their job to defend the Prime Minister, and it was our job to know our stuff, and we didn't know our stuff. So obviously they're not going to tell us all this stuff, because otherwise they wouldn't be defending and they would have been in violation of their job, wouldn't they? So I for a minute there was thinking, oh, they should. But where they are bad, Brent, is that the judge told them to contact with us and help us a wee bit to tidy up so that they could understand with us, and they did not contact us. And when they did, and I don't think it was fair of them to submit their applications. I think that they're supposed to disclose. They're supposed to tell me what they're sending to the court. I don't think they're allowed to send it to the court on a Friday. They send it to the court on the Friday, and you cannot answer them. And I don't know if they're allowed to do that in law, because I thought they had to give us a few days' notice. I'll ask Norm about that. They were, so if it was the case, the going to the court was on Monday, they would reply to what we had submitted. We would submit everything to them. We submitted everything of ours, absolutely everything, to be clear to them and have good disclosure. But they would wait until the Friday and submit to the court and submit to us. We would only get it on the Friday, and we had no time to reply. And I think that they failed us in that way. And I don't think they needed to behave like that. But I don't know if that's the law or not, because I thought they had to give us a little bit of notice. But I'll leave that. You'll let me know that, Norm. So anyway, let's keep going. This is going to be, it's going a long ruling. So there's been quite a few surprises. So he hasn't stood with them. He hasn't stood with us. The scales are balanced. All right? Do not give John Winner or Andy Devine any money. Oh, yeah. Yeah, I agree with you, Danny Jones. I agree there. But, you know, Danny Jones, so Danny Jones has sent
What
me.
did he say? What did Danny Jones say?
I'm not going to say the names, because these are people that I sometimes talk with and we get into arguments. We're in opposing, but it was a common law group, and I'm not going to mention the names, but it's just that he said, they are a scam, and do not give them any money. And I agree. A lot of these common law groups are scams, and in an actual fact, we've already won the thing that we set out to do. We wanted to prove to the people of New Zealand, Australia, England, Canada, we wanted to prove to you that you can get into the court, that you can file a case against the Prime Minister, that they will listen to you, and that you don't need to pay $100,000 for a lawyer. We went on to this case. I did pay $500, but I only paid the $500 because I was working. But you can get into them. But what I want to say about these common law people, listen to me about the common law people. Those people have been working. They all had the right idea. They have been working on this stuff for 30 years. Some of them, it's been their entire lives. That they knew that something was wrong. They knew that they had these rights, but the 1688 will and Mary had been hidden from them. And they didn't know that they could use it. They have been told that they couldn't use it, and they never knew that the 1688 William Mary has not been used since 1976 was the last time that it was ever used in the history of the world, and it's never been used. And so this has been hidden, and this was my complaint to the court, is that they never speak about this. They stopped teaching it in the schools. They removed any trace of it. Whenever they do use words for it in the court, they never ever show the glory where it comes from. But my complaint is when they do the 1990 Bill of Rights Act or the Human Rights Act, they show it up their front as it is the pretended title of the Crown. They bridge it onto the 1688 Will of Mary, and then they cover the Will of Mary with that, and then they claim to be the power when they are not the power. And that was my complaint, because that's a pretended title of the Crown, you see. So that was the complaint that I did actually send to the court, that they must identify the entity of who they are. And if they use anything to do with the 1688 Will of Mary, they have to identify that. So these poor common law groups have been running around the cat chasing the tail, when in fact they could have gone to the court. So I'm just, Kate Floss turned up yesterday. I just turned up yesterday. And so I don't want to criticise those people that have spent 30 years of their life trying to fighting the parliaments, and they've got very extremely valid points in some areas. So let's just still give a clap for them and a shout out for all of them. I'm not saying that I'm better than any of those people. I really am not. What, Brent?
I heard something. I heard you say something then that really kind of triggered me, because they expect us to be particular, yet they are not so particular when they are using the subordinate laws.
And
They're
when
very
we
particular.
and when we go back, keep that right, make a note of that, because that's what we'll be saying. They expect us to be particular, and they're not particular at all.
Yeah.
They are ambiguous and arbitrary, and we don't, half the time we don't even know what they're talking about. Because I've gone and I put in our second case, I put one reference to the Commonwealth of Australia 1900, one reference. And part of the reason they struck me out is because he said that's not in New Zealand law. But when I went into when I go into every single one of their subordinate cases, they are swamped, absolutely swamped with foreign laws. They've got the American Constitution in there. They've got citations from America. They've got citations from Canada. They've got citations from England. And the only way you can and then they've got the hundreds of United Nations human rights, Indigenous rights, charter rights, terrorist rights, all the rights, refugee rights, everything in there. And you can't even read their documents anymore. And that was my complaint, that they're waterboarding. I said to the judge, they're waterboarding us with laws. And all I needed to say was that word vexatious. So that's, the judge just told us what we need to do. He said, you don't have to say all that. All you need to say is this one little thing, 15.1. That's all you need to say, and that explains everything. So that was very good. But and then he said to me, the Commonwealth is not part of Australian law. There's going to be a log video. We're an hour and 38 minutes, but people that want to stay, people that want to go. I've been involved. Okay, not Norma's saying I've been involved in this game, being a common law content provider for over a decade. Yeah, you see. And Buddy says, I've been watching your amazing efforts for a while. And he says, uncovering the real nuggets. And he says, I embrace you, Kate Floss. And he says, I'm happy to assist. So this is what we want. We want these common law people that are really, really savvy. Yeah, they've been doing this for
Yeah.
decades. I turned up yesterday. These guys here, they freaking know their stuff. They really, really do. And now that they've seen what
Yeah.
we've done, and we hear it from the judge, everyone's going to come in now. And we all know we've got our teeth sharpened. And he says he's happy to assess these. You want people like this Norm who really know
Good.
their stuff. And now that they've got
It's
this,
going to pull us all together too.
eh?
It's going to pull. We're divided at the moment. It'll pull us all together.
Yeah, this is going to pull us all together. He says there is always remedy within the law, yes, and he's giving it to you. And this guy seems very, very nice. Just not easily. He's not giving it easily, but he's giving it. It's reflective of the importance of what you are doing. So it's what Norm was saying. The judge knows what you're doing, sees what you're doing. He says it's important, but he's saying you've got to be sharp. If you want to go to the Supreme Court, you're going to lose it. And he's saying, I think what he's saying is if you stop right now, you go back and take these points, you will win if you come back stronger with your teeth sharpened. And that's what they're saying. So, and not Norm's on board. But yeah, we don't want to criticize the common law people who a lot of these things have been hidden from them. And we're just realizing now. So, and as Brent says, this is going to bring us all together. This is going to be like a worldwide movement. I reckon we need to choose a name. It's going to be huge. We're all going to be fighting this. It's going to be beautiful. Don't listen to the naysayers, but do be careful when you go down the common law, because a lot of the common laws people, this is the only thing I will say, a lot of the common law people are saying you can't go to the court, don't go to the court, we don't recognise the court. Well, you've cut your own throat if you do that, because the only means for us to get anywhere is by recognising the court. We simply, whether we like them or not, we have to recognise their system. Even if we think that their system is no good, presently it's the only system that we have, and we have to recognise it if we want to win. So that's what I'm doing. I'm not listening. I'll get these people, and the court is the real cold face. Don't know what that means, but the black face. I suppose you can't say black face.
The coal face, you know, like the person doing the hard yards, the grunt work.
Yes, they are, and
People.
I think right. He's saying that. Yeah, it's where the real work is done, which is what we're doing. Yes. Yeah. So this is where the real work, because see, the thing about this ruling is, doesn't even matter if you lost, and we probably have, but we know it's okay because we've got Norm now. But what they're saying is, now I was going to say something important there. Even though we've most likely lost our case, that's not the important thing. This case is gone into into history. It's been put in history, and it will be used for all times to come. And anybody can go and look at this case. All you common law people, all the common law can go and look at it. You can see where we went wrong, and you can come back stronger. You don't have to rely on us. We want all of the common law people to all go and do their own one and look at where we have failed and get the advice from Judge Cook. Justice Cook has given the most wonderful advice. Take it, and let's all be, and you can all go file your own cases. So this is not a bad thing. Arguments. Mr. Gunn accepted that the applicants were genuinely concerned about, Mr. Gunn, he's the Crown Counsel, concerned about aspects of New Zealand law. He accepts that, and that their grievances are deeply felt. So even Crown Counsel says, yes, we agree with what you're trying to say. He also accepted that they were not lawyers, meaning we're not lawyers, and that some latitude was appropriate. It was very nice from Crown Counsel. The problem was, however, that there needed to be some proper case advance to respond to. I agree. And the pleadings fell well short of that here. Okay. He argued that the Crown must have a reasonable idea about what the case is about, and that the relief sought was something that the court had the jurisdiction to grant. He reckons that the court has got no jurisdiction to grant us a declaration, but they already fought it in the Yardley case where Justice Cook, was it the Yardley case? No. In the Taylor case, the Crown Counsel said exactly the same thing. In the Taylor case, the Crown said Taylor was trying to get a declaration of inconsistency for the 1990 Bill of Rights Act. And I had said, why can they get that and we can't get it? Because this is what the judge said. The judge said that under New Zealand, I might not have it here. 90, I might not have it. But the judge anyway said in 104, he said that such development is consistent with the statutory recognition that the High Court has the judicial jurisdiction that may be necessary to administer the laws of New Zealand, laws which now include the Bill of Rights Act. But he also said, let me get my it's here. So in the section 93 of Justice William Young, he said that the Crown had said that the court had no right to give a declaration of inconsistency in the Bill of Rights Act 1990. He said the Crown has not sought to argue that judicial review cannot be available. Rather, the Crown argues that the court does not have jurisdiction to grant declaratory relief, that legislation is inconsistent with rights confirmed in the New Zealand Bill of Rights Act. Now, I put this in my case because I said they already said that in the Taylor case, and the judge, and they said the court had no jurisdiction, and the judge answered. And here was the judge's answer. He said, the suggestion that the High Court has no proper function in declaring rights unless the declaration has further consequence for legal interests seems to me to be overboard. So he said, the judge said, you don't have to have legal consequences to get a declaration. You just can ask for the declaration as a right. And then he went on to say a bunch of other stuff. And he said that the jurisdiction was okay and you could do it. And then he went on to say, under the Declaratory Judgments Act of 1908, have a listen. This is what the Declaration Act says. No action or proceeding in the High Court shall be open to objection on the ground that a merely declaratory judgment or order is sought thereby, and the said court may make binding declarations of right, whether there is any consequential relief claimed or not. So you don't have to claim that you want any remedy. You don't have to claim that you're prosecuting. You can only just ask them for a declaration, which is what we were asking for. Only. And he said, this standalone provision makes it clear that binding declarations of right may be made whether or not consequential relief is sought is distinct from the jurisdiction recognised by S3 of the Act. to make declaratory orders. So basically, in the end, they got the declaratory order. That had already been argued. So I'm not understanding why. Well, let's wait to see what the verdict is. He said, he argued that the Crown must have a reasonable ideas. Yeah, that's what I said, Norm. Norm says you're well within those criteria, and I argued that in court. He argued that the Crown must have a reasonable idea about what the case is about, and that the relief of sort was something the court had jurisdiction to grant. But I only asked for the declaration. That's all I wanted. This was not the case here. He accepted that a further adjournment, could be granted to give a further opportunity to remedy the deficiencies. So now we're up again. But he said that the deficiencies were fundamental, whatever that means. So let's see,
Not good.
So Miss Sixtus argued, we had taken that out. How did he get that one, Brent? That damn clerk. The clerk has put in the wrong one. Our one, that clerk is in a lot of trouble. That clerk, he gave the judge, on the Monday, we sent a new memorandum, but the clerk, we had removed the word Marsden Point Refinery. But in this new memorandum that the judge is commenting on is the one that had the words, the Marsden Point Refinery. And that's what was given to the judge.
No.
Yes. Yeah.
We sat there, we sat there for ages talking about that, you and I.
Yeah.
About whether we should mention Marsden Point, and we said no. Marsden Point was out. You need to go back and check that you sent you.
I sent it. I've got the proof. I've got the proof, and I've got the proof of who I sent it to, and I've got the proof of the one that I sent. And the clerk has given the wrong one to the judge.
Go back to the one you sent and make sure that Marsden Point definitely was taken out of it. But I recall that because that was something I was bullish about. I was like, no, we shouldn't be talking about that.
I took it out and we rewrote an entirely new memorandum.
Yeah.
And so I sent.
That's business stuff. That's got nothing to do with us.
I sent a new memorandum. And okay, right, Norm, I sent a brand new memorandum explaining everything. And it doesn't have Marsden Point. And it's a whole new memorandum. So I don't know why.
So he's not seen it in court.
Eh?
He's obviously not seen that in court either.
No, he won't have. So, but don't worry, because Norm says don't worry, because he's left the door open for a reapplication.
Yeah.
And he said he really feels that the judge is on our team. So Norm's on the team now. So he says he really feels that the judge is on our team. And so we already know that it's not great anyway, and we do need to fix it. So I think that we will not get ourselves caught up in the clerk, but we'll all be very aware of. I think it did get a bit messy with all the 2 claims in and everything. So it's probably quite a good idea, but it is a sneaky thing to do, isn't it? Oh,
Mm.
still sneaky, isn't it? And so he sent him back. But I know that he got the interlock. The interlock, I know he got because the judge specifically asked me about certain points and I responded to them. Okay, so are you still got the screen on there?
Yeah,
It's behind it, Kate. You don't need to open it again.
Is it? Should
You
I?
can see it. That's the one. No. You've opened it twice.
Does it matter?
Just had where we were up there.
Oh, it's
below.
there. All right, I see. Okay, I see where you are. It's there. Okay, oh, thank you. All right. Okay, let's keep going. But anyway, I did send an interlock, and the interlock was very good. So he said we had asked for a temporary injunction order on certain things. So he says that Ms. Sixtus contended that the claim was an appropriate one to bring. She relied on the observations of Alias CJ in the Attorney General versus Taylor. He's put that in there, that there did not need to be consequences for legal interests before a court could make a declaration. She said that the applicant's legal strategy initially focused on a declaration that would consolidate the legislation passed of 1865 and 1908, and that after that initial step, the other aspects of the claim could be addressed, because that's what we said. We said we're not interested in all that, but we only want the declaration first point of call, and then we were going to do those cases one by one. We just gave them an example of why we wanted this declaration. And then after that initial, so I told the judge that, give claps. All right. Those other aspects included a challenge to a number of government initiatives which she argued were being introduced in a way that amounted to psychological waterboarding. I said the government are waterboarding us with law. She confirmed that amongst those complaints are those listed grievances in her earlier memorandum, which by way of, he's got the second memorandum, he's read both of them. And then he has added that she confirmed that amongst those complaints, he put Marsden Point on it. I took it off and he put it back.
Really?
Yes.
Wow.
Yes, Marsden, we said we wanted a suspension on some laws that were being passed in Parliament that we could not. We said that we were not able to fight all of these laws at one time, and we asked for 100 days reprieve, and we used but he took out the who. We had put in the who, we had put in the 50% Maori Parliament, we had put in the United Nations Declarations of Indigenous People, but I had put on there the who, but he'd taken that out. But I had taken
Scroll
out.
down, there might be more.
Oh. Our first memorandum, we had put in about 15 things that we wanted the government to stop for a moment in time to give us time to fight them. And we said they've been waterboarding us with the laws, which is against that 15.1, because that's vexatious. And so this is very important. So we had, in the second memorandum, we took out most of them and we only just chose a few. But he's put them all back in. So
Brilliant. He's definitely guiding.
So we've got, this is the list from the first memorandum, had the Marsden Point Refinery, the United Nations Declaration of Indigenous, the Three Waters proposals, the allegations made by Judith Collins, which I don't remember putting that, the 50% unelected Maori Parliament, allegations concerning the New Zealand health system, health department, and the dividing up of it according to race. I can't believe he's put this. The establishment of 2 Mormon temples, which is endangering the safety of the Protestant religion. He's put it out. The teaching of false history and non-heterosexual promotion to children. The taking of farmland and strict regulation of natural areas under the Resource Management Act. The disarming of Protestants of their firearms. The Terrorism Act. The Sustainable Development Goals as required by the United Nations, and an allegation concerning the LexisNexis laws. And we said they've been waterboarding us with their laws. It's vexatious. It is vexatious. He's put it on it.
Did he say that? Did he put vexatious in there?
No, he hasn't. He hasn't. But in the earlier one, because in the earlier one, the Crown Council in the vexatious said we put too much in there, and that was vexation by putting lots and lots of laws against one person. And then he didn't say that we put that, because he can't put anything that we don't write. But we did say in our non-legal way of speaking that they have been waterboarding us with laws, which is exactly the same, even though we didn't use exactly the law, but we said exactly, and then we listed all the laws that they had been waterboarding us with, because we said we can't cope anymore, we can't function in society when they behave like this. Oh, God, this is just, yeah.
I think the Judith Collins one is referring to like the Matua family. You know, there's a conflict of interest there with, is it the Matua? I don't know, Sharon, Maxine.
Mahuta.
You know, the third, Mahu. The family, you know, how she's got her family in with the Three Waters. Judith Collins' husband had to step down, didn't he? Because there was a...
Oh, you're talking about the
Nanaia.
I remember. No, when Judith Collins, this was years ago.
Oh, the business dealing with her husband.
Yes.
That's it.
No, I'll have to go back and look at the memorandum.
Tea over in China?
No, that's nothing to do with it. That's a different case. No, because that's a different case. No. But Judith Collins must have made a complaint about something, and I'm not sure what those allegations, but I'll have to go look in the proper memorandum to see what it was about. I'm not sure, but I think that we don't need to focus on that because it's irrelevant, because there's so much good stuff in there. There's a lot of good stuff in there. I don't think we had to focus on that one point, so we can just ignore her and not. But he put it in there anyway. I don't know why he thought he should put it in there. But right, everybody, hold your breath. So the scales are balanced. We've got some good things for the Crown. He said his stuff. Got some good things for the applicants, which is us. Wow, we don't know what's going to happen. It could go either way.
It could.
It could go either way, or we might get something. Let's have a look. So here comes the decision analysis from Justice Cook. I accept Ms. Sixtus's point that the jurisdiction of the court to make declarations is a broad one, and that it is not necessary for there to be legal consequences before declarations can be made. Unfortunately, it is a boom, but unfortunately there's a but. There's never good when there's a but there must nevertheless be some issue about a matter of law. But I think there is. to which the declaration is directed, and that is identified in the pleadings before the court. It's not looking good. I thought I did have good issues, to be honest. He says, here there are two interrelated and fundamental problems with the pleaded claim, which I do not accept can be remedied by amendment. So he said, he has basically said, you can't, he shut the door now, Norm. We thought it was open, but he slammed it shut in our face because he says none of what we've pleaded can be remedied. So he's saying this entire claim is no good and it can't be remedied. All right, but don't worry because we can appeal. So he says, and it's ended. The first point is that the allegations are unintelligible. It is not possible from a reading of the statement of claim to understand what allegations are being advanced in relation to particular rights or other legal matters, and what it is that has led to a relevant issue about them. The allegations in the statement of claim are very broad. And it does not identify particular disagreements, which I don't agree with him, or uncertainties in relation to matters of law that would be capable of being the subject of a declaration. The applicant's memorandum responding to the criticism and the oral arguments advanced by Ms. Sixtus did not make the position any clearer. I accept Mr. Gunn's point that the pleaded claim is unintelligible, and that is essentially the same conclusion that Palmer J reached in relation to proceeding in Moore versus Farfoy, which were struck out on 18th of May. Well, I disagree, but what we're going to do, everybody, don't be sad, because we've got Norm now, and Norm is savvy, and we've got EM Real, and he's savvy. They've been doing this for years, and we might have Danny Jones. These people have been doing this for years, and we'll just take this, and we're going to be coming back. So we're not. All right. But he said this whole thing cannot be remedied. He's basically said put the whole thing in the bin, which I don't think that he needed to treat us like that. Secondly, to the extent that it is possible to discern the allegations made, many are not within the jurisdiction of the court. The matters listed as grievances referred to in paragraph 13 above involve matters of policy, and some involve criticisms of parliamentary enactments. That is so in relation to the first declaration that Ms. Sixtus advised was being sought, which seeks a consolidation of two ancient statutes. This is referred to in the first declaration sought in the statement of claim. Such matters are not within the jurisdiction of the court. Why?
What?
The grievances involve political issues and debates on matters of policy. The court is concerned with questions of law and to resolving genuine disagreements or uncertainties on the meaning and effect of legislation or other legal instruments or questions. It does not have jurisdiction to determine questions of policy.
I've got it.
What?
You know what? We have to really, really simplify it
Yeah.
and not bring up any of that other stuff. All we want is to know is the 1688 Bill of Rights our supreme law, or is the 1990 Bill of Rights Act our supreme law? We need to simplify it.
Yeah,
Just keep it
that's all
simple.
we need, isn't it?
It is.
That's it.
Yeah.
I agree with that.
I
Why don't
agree
we,
with that fully.
why don't we just put in a claim for the higher law, and everything else can come later? We
Yeah,
don't,
forget everything
Yeah.
else.
yeah,
You've just got to get that one
one
declaration.
paper, just the
Nothing
one
else.
paper.
We only need one declaration, because if we go to court to fight anything, they're going to bring in United Nations law, 1990 law, hundreds of laws against us. So we only just need to know that that is the supreme law, and then we can do the cases one by one. We
That's
put
what
in
we're
four
saying.
cases,
That's what we're
four,
saying.
eh?
Yeah, but we don't need
Just
that
go
in
for
this
that
case.
one
This is any
paper.
of it. This is causing confusion for them.
Yes.
They need to know the particular, the one thing that we want is that declaration.
They
On
agreed.
one piece- on
They
one-
agreed in the court that the law was that the 1688 preceded the New Zealand 1990. They
And
agreed
that's what we need.
Did they agree?
Mhm.
Where did they agree?
in writing from the court.
Where did they agree that?
That was in the transcript when the first meeting that we had with Peter Gunn.
Gunn.
He agreed. We've got that in writing. What he said.
Oh, have we got
Specific.
that?
Yeah, we've got that.
Oh. So we'll just
All we
do,
need is it in writing.
we don't
from
have
the
to prosecute anyone. We can only just ask for the declaration, right?
Yeah,
Yeah.
no respondents, no, nothing, no,
Nothing.
it's just the claim.
Yeah.
I think having the respondents there made it
Yeah,
difficult.
made it hard for them. Yep.
What it was doing is it was causing a case to be made, and I could see where they're coming from. Because you've got
Yeah.
respondents, you're asking someone to combat you in court.
Yeah,
We're not going into combat. We were trying
No,
to get our
we're not.
declaration
We're
at the
going-
same time. We get a combat. So
So
It
we
was
just
a-
take
yeah.
all of that out and we just only make one case saying which one is supreme,
Yeah.
Yep.
1688 or the 1990
knock out the-
and
knock
United
out the
Nations.
Bora.
Eh?
Simple.
Knock out the Bora. Get the 1688 as our supreme.
Yeah.
All right, that's what we need. So if the court recognises the maxim first in time is best in law, then the 1688 stands. That's what Norm says. And he says, yes, I think all you are seeking is the court's determination. Yeah, I
Yeah.
wasn't actually wanting to prosecute, but I thought that what I thought that I could do is put up the examples of why I needed it, and then I was going to interlock that. Then if I got the declaration, then I was just going to go and prosecute each one of them, boom, 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 boom. But
They couldn't give you the
and they didn't
declaration
see
on
it,
that.
and they didn't see it
Yeah.
like that.
yeah, no, they
They
didn't
didn't
see it
see it.
like that, exactly.
It's processes of the court.
Yeah,
Yeah,
Yeah.
all right. Right, all right. So,
We just overshot our mark a wee bit. We just
but all good.
But this can all be used later.
Yes,
It can.
yeah.
because he did,
Got all your bases there. You just need to get that declaration.
Declaration, so we
separately.
can proceed further.
he
Yeah.
said, I accept Ms. Sexter's point that the jurisdiction of the court to make declarations is broad and it's not necessary to have legal consequences before. So he's already said that. He said, you don't
Yeah.
have to have a legal consequence to get a declaration. You can get just a declaration.
Yes.
Yep.
Yeah.
Yes,
Right.
that's what he's saying. Yep.
Yeah, Norm says,
Yeah.
if you can get the court to rule on this, then it's a slam dunk for anything after that fact. And yeah, that's what we're
You're
trying to
right.
get.
Exactly.
You're right.
It is.
So,
Yep.
what was I going to say? I've forgotten.
It'll come to you in a minute.
Mm.
But anyway, so he already accepted that.
Yeah,
And he said that we can get a declaration and we don't even need to have a legal consequence.
That's it. And he's given us all them guidelines along the way.
Yes.
but that's what I said to you, Kate. The legal counsel most probably came in because Jacinda Ardern, Chris Farfoy, and Chris Hipkins, and Andrew Little were all named in our application. So straight away they brought in the counsel, legal counsel.
Right. And all right.
And they thought we were going straight up against them right there, right then. So they didn't know how to fight it.
Right.
So what we have to do is just follow the
Declaration.
guidelines that he's given us in this.
Yeah.
He's given us all the guidelines to get to where we want to go.
Yeah.
We just have to simplify it to that one thing, which
Yeah.
is the
1688.
best, 1688 or the Bora,
Yeah.
and he's given us the guidelines to follow to be able to get to that
Yes.
Yeah.
and win that.
Yeah.
Yes.
And the rest will all come after that.
Yeah.
And yeah,
Exactly. Yeah. So
we
that's
never lost, but we're going to win.
yeah. He did accept that. So and then he said, where did he talk about the ancient right?
Oh, sorry.
He called them both ancient. He even called Bora ancient.
No, he
because it's
didn't.
19.
No, because
No.
I was
What's
using the
that?
1865 and 1908.
Oh,
Yeah.
was it?
It was the magistrates. Hang on. Oh yeah, he said this. He said the matters listed. Hang on. What he tells you you can't do. Oh, here's something cool. EM Real says he's given you all the steps needed. Great stuff. EM Real says hard case really. You're putting a fly in the ointment. Keep going, hun. So that must be a female there because she called me hun, or unless it's a man that thinks that I'm really gorgeous. So, and then Norm says, and Norm says,
You don't have to think you're gorgeous to call you hun.
well, if a man calls me hun, it usually means that he quite fancies me, or otherwise it's a woman calling me hun in a friendly way. So I think it's a woman.
I do that to you.
Yeah, because you're a woman, but usually a man will not say hun because you might get misinterpreted and think, well, usually, I would think they'd quite fancy me and be wanting my phone number, or would they not?
Moving forward, Macduff. Moving forward.
Right, moving forward. So Norm says what he tells you, here, this is so perfect from Norm. Norm says what he tells you can't do tells you what you can do. So
Yeah.
that's very, very good. Right. And so then he says here, the extent it is possible to discern the allegations made, many are not within the jurisdiction of the court. And I agree. The matters listed as grievances referred to in paragraph 13 above involve matters of policy. Some involve criticism of the parliamentary enactment. That is so in relation to the first declaration. So he's only talking about, we haven't lost yet. He's speaking to the first declaration where we had asked for a consolidation of two ancient statutes, the 1865 and the 1908. He says this is referred to in the first declaration sought in the statement of claim, but he said such matters are not within the jurisdiction of the court, but I don't know why not. The grievances involve political issues and the debates on policy. The court is concerned with questions of law, yada, yada. So he does speak of the two ancient, but he said, so he's given us information in regards to the two ancient statutes. He can't give a consolidation of them. It's not within his power to do that, which is a bit sad. So he says these deficiencies are not capable of being remedied by amendment. The deficiencies are too fundamental, an opportunity was earlier afforded to review the pleading, but Ms. Sextus have made it clear that the key allegations currently outlined are the basis of the claims. I see no prospects of the deficiency being remedied. All right. I did ask for the 10 days, but he said no. But I think it just needs to go back and be redone completely. So for these
Yeah.
reasons, the proceedings are struck out as an abusive process. The respondents would normally be entitled to costs, and it is appropriate for parties to propose litigation to understand that there are usually costs and consequences of bringing proceedings that are found to be an abusive process. If the respondents seek costs from the applicant's counsel, may file a memorandum within 10 working days, which can be responded to by the applicants within a further working days. So now we're in the poo, because
Now they're going to try and sue us.
now they're going to sue us back, but don't be despaired, because we will just see. But I think that we'll be able to say that it's in the public interest.
Yeah.
And so we might, I don't know, but Jacinda, I suppose we'll have to pay for the council. But don't worry, because I've got my husband's retirement money, so it can't be that much.
We'll figure it out. We'll figure it out when it gets there. Don't
Yeah.
worry about it for now.
Yeah,
We'll worry about that
exactly.
when it's
Yeah,
So, Kate, the only thing that I would say in feedback with that is you've given them a list of what you're going to hit them with. So, how fast can you turn around the declaration, like getting that redone to get that declaration done?
we got a good team here. Who's asking that? Is that NW?
Yeah,
NW, what's your name, please, dear?
Nadine.
Nadine. Right, Nadine. Right, listen up, everybody that's in here. We've got Real Me, we've got Norm, and then we've got Nadine. I don't know if these other people want to be involved, but it sounds to me like Nadine knows exactly what's going on. So what we're going to do is we're all going to, anybody that wants to be involved with this, get in contact with me. I'd love to read through this. Anybody that wants to be involved, you've got to send me your emails, give me your emails or contact me, and I'm going to send it all to you, get you hooked up to my messenger group. I've got a messenger group. We're going to bring everybody in there, and we all are going to hit this as fast as we can with whatever it is that we can. All right. He did not make any comments to do with prayer 2, prayer 3, or prayer 4. And so I've got to send the whole, whoever wants to be involved. We don't want pussyfoots. We don't want people that say to us, I don't have time, or I can't be. If anyone wants to be involved, that's just like Nadine said, we've got to hit this back as fast as we can. While we're fresh,
That declaration needs to be done ASAP.
we really need it. And so we'll have to hit the court immediately, wanting just that. We only just want to know which one is the supreme law, and see if, and take out all the rubbish. But I think we should. So if anyone wants to be involved, we would be most happy. Send me your email. I will send you all of the court things that we sent in. There's quite a bit of reading. It takes a bit of understanding of Kate Floss. I have got a bit of a weird brain. So I don't know, you read it, you might understand. If you've been involved with these things, you would know. Yes, what do you want to say, Sharon? I can't hear you, Sharon. I can't hear you, Sharon.
She's on mute.
Oh, we can't hear you. She's on mute. All right. So Norm says, have you tried asking under an FOIA request? What's that? FOIA.
Freedom of Information. Freedom of Information Act.
No, because we want a court order. We don't want their affidavits. We don't want we want a court or a
Declaration.
court. We want a declaration. We want a declaration from the court to say that this is so. And we don't believe that these affidavits that they're sending us, the common law people have been getting these affidavits for decades and they are useless. You need, I'm trying to force a court ruling that says this is your supreme law against the 1990 ordinary. That's what we're trying to force. So
That's what we're going for sure.
that's what we, because anything less than that is no good to us. So if anyone, but Norm says, yes, but you can get some ammo.
Can I just
I don't know because if they already know that we're coming. It's like Nadine says, they already know that we're coming, and they know that we're coming back. And so I just don't think that we should give them the opportunity, because if you get an affidavit, see everything that he said in here, it's on law, it's on record, and they cannot change it. And he has said some very good points. But if you get an affidavit and they've got lots of time to think about it, they'll give it to you after a month. They've got lots of time. I think it just gives them too much ammo. Yes, Sharon.
this is for Norm. Norm, would you know the reason why they won't consolidate the two laws, or it's not within the jurisdiction to consolidate?
Very good question. Norm, we're asking you this question. Would you know why in New Zealand we got an 1865 declaration that said that all New Zealand people would be subjects of the Majesty? And by saying that we are subjects of the Majesty under the 1688, it's a forever document. It says for all times to come, it can't be changed. That was given by Queen Victoria. And then in 1908, King Edward VII gave us a consolidated, that they redid it again and said that New Zealand people would be subjects of the Majesty a second time. So we don't really understand why they can't consolidate. Do you know any ideas there, Norm? You have to wait. No, Norm has to type. So we have to see what we have to wait, because he might be saying something. So we just wait for Norm to talk about that. So I think, there were other declarations in there that we'd asked. So I think that what we've got to do is separate the 4 declarations, and instead of asking for 4 declarations, we're going to ask for one on the same points. We're not going to ask for 4, and we're not going to prosecute anyone. So can we just
one at a time?
Do we have to have I've seen some people go and they put the Queen. Here, let's see what Norm says. Not sure on that. I'd need to look at that decision. Possibly could be Privy Council level. Oh, yes, it was. It was directly from England. The New Zealand Maori in what had happened was the Sextus family, which are my ancestors, 5 brothers, they went to the court. They were the first ones that went to the court in New Zealand and asked for a declaration. They became naturalised as British citizens. And when they became naturalised as British nationals, it says on there that they will be known as natural-born subjects of the Majesty. And then a second time, Thomas Wakanene, who was a New Zealand Maori in 1847, he went to the court and got naturalised as a British. And so do we have to go to the Privy Council with it? Oh, no, he didn't. And so then in 1847, Thomas Wakanani got made a subject of the Majesty, and then in 1858, two more of my family got made a subject of the Majesty as a natural born subject. Then in 1865, they consolidated all people of New Zealand and they made all people natural born subjects. And then in 1908, that was done under Queen Victoria. And then in 1908, King Edward VII, he also made New Zealand people natural born subjects of His Majesty at that time. And then that 1688 indubitable right is a forever law. Once you're born to it, you're born to it. The only way you cannot be involved with it is if you renounce yourself. So he said, you still just asking for the court in the form of a declaration. No need for outside jurisdictions to be involved. Right, I tell you what, this Norm is very, very clever, and he's going to lead us in the right direction. I hope he will come and I hope you're going to be on board with us, Normie. What do you want to say, Nadine?
So first and foremost, it's getting that declaration of which one, 1688 or 1993, 1990,
Yeah.
and then it's looking at that consolidation and if that consolidation is needed.
No, we don't want to just consolidate them because they are repugnant. The 1990 Bill of Rights is a United Nations law.
No, she's talking about the ancient laws. She's
So
talking about the ancient
1908 and 1688.
Yeah.
Yeah, we just want to.
1988, the
65.
1865 and the 1908.
Yeah, that's your consolidation.
Yeah, that we wanted to consider for consolidation.
We
But
want
that
a
needs to
new
happen if you get a
declaration.
declaration.
We want a new declaration that says that declaration there still stands because it's never been repealed. So we
Yeah.
just want them to say, yes, it still exists. That this does not been
yeah, so-
repealed and it still exists. Oh, I
So
see
it's
what
getting
they
a
mean.
declaration
No,
that in
what they said is
1688.
we want to join those two declarations
Yeah.
and make one new one. That would be a consolidation. We've worded it
Yes,
wrong.
it is.
So we should only just ask for a declaration that those two rights still exist.
Yes.
But Nadine is saying that we should get the declaration first and then see
Yeah.
about the ancient laws. Aren't you, Nadine?
Yeah,
We
so
need
get your declaration to state that. Get your declaration to state that the 1688 stands over the 1990, and
Yes.
then look at getting that consolidation of the 1908 and the 1688.
Yes.
Well, because when they removed the Constitution in 1986, we had the 1852 Constitution, and they removed it in 1986, and everybody thought that also removed the 1688. But then
Yeah.
for some reason in 1988, they got told that they were they were operating as a dictator, and they weren't operating in the way that any recognized government should. And so in 2015, they put the 1688 Bill of Rights into New Zealand legislation properly, because before it wasn't. Before it was just the Will and Mary that was the UK, but we actually have got it put in our legislation in 2015. But I'm not really understanding why all the things that the government are doing are repugnant to it. So how can they be doing that in repugnancy, even though it's there in legislation? So I asked the court since they're repugnant to each other, because the 1990 Bill of Rights it's got two laws in it, right? Section 19, eh?
It's UN, yeah,
Yeah.
section 15 ties it to 93.
Yeah, it ties it to the 1993 and then of the human rights, and then the human rights section 5, subsection 2, KII says, report to the Prime Minister that New Zealand will be bound to any international instruments, any. And then, but then it's also got the S28, which says that all other rights are not affected by this 1990. All other rights are outside of it. But then the United Nations came back and attached to their case that S28 applies to every single right that was created pre-1990 comes under S28. So any rights that the United Nations got pre-90, they've tried to attach it to S28. And Justice Cook said, no, you can't, but he said, go to the High Court and see if they will let you. So I wanted to stop all of that. So it's not as easy as what you think.
including the Treaty of Waitangi was in there 1993 when Māori said no, it's not to be put in there.
The consultation, here's my complaints. The consultation for the 1990 in the select committee, they said that they would never issue a remedy for this Bill of Rights because that Bill of Rights includes thousands of United Nations law, and if we violate any one of them, we have to give a monetary thing to them, right? So, but oh no, what I was going to say. So that was the select committee said that they must not provide remedy for it, and I think that's good because the remedy for the 1688 is only a declaration. That's all. There's no monetary remedy for you. You cannot get it. You only get the declaration that says that you have that indubitable right. Now, but the remedy is that Parliament has to stand down if they go against it. So that's also, but there's no monetary gain. And the Treaty of Waitangi, which is not really in law, but the Treaty of Waitangi, they put it into law in New Zealand legislation in 1975. Previously, it was never in New Zealand law because it only says, ask the chiefs to concur, but not actually say yes, but concur. And they concurred, and then in 1865, they went and got their declaration that they would go under the Queen's law, but that was 25 years later. But when they were making the 1990 Bill of Rights, we've got evidence. Justice Venning said that when everybody was opposing the 1990, the New Zealand Maori Select Committee, they had their own select committee, and they absolutely forbid the Treaty of Waitangi to be put in the 1990 Bill of Rights. Well, because they knew how important the treaty was. Well, 3 years later, they turned around and put the treaty into the Human Rights Act, bound together with the 1990. So they're doing lots of little sneaky little things here. And then not to mention that when Peter Sharples went to the United Nations and signed up, there's evidence, loads of evidence to this. When he signed up to the United Nations Indigenous rights and put the New Zealand Maori into it, and the Australian Aboriginals went under it as well, they promised, they said absolutely that this would be non-binding. It would be non-binding in New Zealand law. But do you know what they did? As soon as they put the New Zealand Maori into the Indigenous rights, they gave the New Zealand Maori a separate legal entity, which was the Tikanga Law Office or the Customary Law Office. And on every single Maori document that they made laws, they have inserted other United Nations laws into it. And even though the Indigenous rights is not binding, because they went into that, all of the other rights that they are all binding, all of those are binding, but the Indigenous is the only one that's not binding. But all they did was go and make another set of rights at the human rights, another one that was not the non-binding Indigenous. And then they tagged that onto the Maori because the Maori were in the Indigenous ones, you see. So they're getting up to all sorts of mischief with our native people. Nadine.
Yeah, they definitely are. I've had multiple conversations about it. So, yeah, coming back to the original point, definitely need that declaration as your starting point, because if they come back and say no, it's not, that changes everything moving forward.
It certainly does, because it's got the supremacy law which forbids foreign governance in our country. It's got it. And it's also got the laws of how the government must conduct themselves. So
There's only one way out if we don't get the declaration.
yes, well, we're not allowed to do that on camera, Brent.
What? Give the
No,
fingers?
we just don't anyway. But anyway, so that's where we all are today, everybody. Our team. So anybody that wants to be involved with this, you can let me know, and we'll send you emails. And we all know
Send me
what
them
the
documents,
eh?
from the court.
Yeah, everyone
So
can
I
have
can
all
read
the
them.
documents now. I'll send everybody. I've got your email.
Yeah.
Anybody wants it, I'll send it to all of you, and we will
Let's reconvene later on in the week, and we'll all read the documents and maybe meet up over the weekend at some point.
yeah, we'll take just a little wee rest, but like Nadine said,
Yeah.
the fire is hot.
Yeah,
The
we're gonna
fire
get
is
going.
hot potato. And if we get in there quickly, but not so quickly that we lose, but he's given us all the answers. We know what we
Yeah.
want. So we've got to get back in there and do it differently. And we're just going to keep going back. But it's going to be very hard to get past this clerk now. Very, very,
Well-
very hard.
Yeah.
Because he
Well, it shouldn't now, Kate. It shouldn't now because we're only asking for a declaration. Surely he can't stuff that up. It'll be pretty dumb if he stuffed that up. We're only going for the declaration. We're not going for anything else.
Anything else?
No one else's names will be on there.
Yeah, nobody else's names will be on there.
right.
It'll be just ours asking for the declaration, and that's it. If he
Yeah.
stuffs it up, he's really, really incompetent.
Yeah.
No other parties involved.
Yep.
Right. Norm's
So they
talking.
shouldn't even be alerted that you've gone back either to request that.
Yeah.
Right, Nadine. Yeah. All right. Yeah. So we won't. We could do it in a different name.
Yeah.
Doesn't
Yeah.
have to be my name.
Put my hand up.
No, I think,
None of our names can be on it. Or should
I'll
I?
put my hand up.
I think
Jody.
as long as you're clear with your messages back and forward, that's your paper trail of that's your paper trail. If you ever
Yeah.
have to thing it, and as long as you're clear and succinct in what you're wanting,
And we can refer to
You'll
that
be
ruling.
fine.
Yeah, and we can refer to that ruling because he did accept. He did say we accept that you can ask just for a declaration without any criminal proceedings. He said that.
Yeah.
So I
Yeah.
think we'll just go down that road.
Yep.
So it ain't over yet. So Norm says, forgive me if I'm wrong, but I'm not sure it's actually a declaration that can be sought first. It seems more like you're asking for the court's clarification of the 60. Yes, I am, but he said,
Well, rather than
which I
saying
think
you're asking
he
for a
said-
clarification, can you just say, I want a declaration to say that the 1688 is the supreme? You make the statement.
well, we'll see what Norm says. He says, which I think is a determination. Once you have that, then a confirmation in the form of a declaration can be requested. I'm no expert on anything, but you sound pretty clever to me. I'm no expert on anything, but he's happy to assist. This guy here is savvy. He is savvy, and he's going to help us. He knows what we're doing. He's going to help us. So you know what? We've got some, and there'll be other. If we do these live meetings like this, there's going to be other savvy people that are going to be coming to join us. I think we're going to end it today, and everyone's going to take a break. Right? We all take a break. When are we going to come back? What we reckoning? We're going to come back on maybe Wednesday, Norm. And Norm, what are you particular about your time, Norm?
We need his we need to get him in on Zoom meetings. You need to link up with him.
No, I'll send him my email. Here's my email,
Yeah.
Norm. Hang on. Yeah, I'll send it.
Someone just asked what's Norm's surname?
Why?
No, Kiwi was asking.
He might not want people to
We're not
know
allowed to
who-
tell people because they might not want people to know. But I've put up, right, Norm. Norm, I've put my email address. My email address is katecando at Hotmail. KATECANDO. Kate Can Do at Hotmail. So anyone can email me and I will forward to you the necessary papers. But remember, it's quite a little bit confusing because we had that cross case come in. I think I will not send you the cross case, but there is a cross case. And so we should not, so don't get confused when you hear them talking about this cross case, which is Moore versus Minister of Immigration. You must not, but mind you, if I put in my case, because they probably know that I'm coming back, they're probably going to charge me a lot of money. How much? Because I'll be charged for.
Just don't worry about that, because what you do is say put it on a time payment of $5 a week, and you can do that.
But
Don't
what?
worry about money. Forget
Because
the
you're
money.
not working.
No, I'm
anymore.
not working.
Forget the
Exactly.
money. Don't worry about the money.
I'll just
we
pay
don't
them.
we don't worry about money.
All right then.
Fuck the money.
Do they charge you interest on that or not?
Who cares? Let them. Do they $5 a week? I'll pay $5 a week for the rest of my fucking life.
I'm in Thailand anyway, so it's not like they can extradite me. I mean, they're
Yes, ma'am.
good luck to you trying to get me out of Thailand because I ain't going.
And they're not going to come after you. You know they're going to come after you for expenses, but we'll just be like, yeah, let's
No.
go again.
Norm says to me, don't worry, he says, we'll sort any alleged debts. So Norm's, this guy's a powerhouse. He's with us. We've got friends, we've got mates now. We're not alone. He's laughing. He's laughing. Yeah, we've got friends now. We're not alone. We may have been stumbling, but the big guns are coming in to help us. And we're going to be fire. We're going to go and get our sword and get our shield and go down that courthouse and slash them all out.
Yeah.
Let's
Yeah,
do
man,
that.
loving. Right, bye-bye, everyone.
Bye, everyone.
Bye-bye. See you later. How to turn this off? I don't know how to end it.